and welcome to Carers Talk, the podcast for carers, where we share advice, information and carers' experiences. My name's Michelle and I'm your host, and this podcast is brought to you by Carers Trust Solihull. We hope you enjoy. On this episode, we're talking all things wills, and I'll be doing so with Shelley Collingbourne from Sydney Mitchell Solicitors. As you may be aware, Sydney Mitchell Solicitors have worked with us over the past couple of years. They have delivered some of our workshops, including wills, power of attorney, and continuing healthcare. They have also supported us with our Carers Rights Day events, and most recently, they have chosen us as one of their charities of the year. So, hello, Shelley.
Hi, Michelle.
Thank you for joining us.
Pleasure.
Shelley, do you want to introduce yourself?
So yes, my name is Shelley Collingbourne and I'm from Sydney Mitchell Solicitors. As Michelle has said, we've worked with Solihull Carers Trust for a couple of years now. I'm a partner at Sydney Mitchell based at our Sheldon office, and we've also got offices in Shirley and Birmingham City Centre. I specialise in our private client team, which means I deal with wills, powers of attorney, administration of estates, but also court of protection matters, elderly client, and also some trusts and tax advice as well.
Thank you. So we're very lucky to have you with us today. There's been a lot of talk from carers regarding wills and power of attorney, how they can protect themselves, maybe their assets, but also to protect their loved ones and make sure that, their wishes are met. So can you tell us about what is a will?
So a will is a document that you prepare and deals with who it is that you wish to leave your money to upon your death. A will is a very important document. It is valid as soon as it is signed and witnessed, and provided it's signed and witnessed properly. And it will ensure that your monies will go to the persons that you want to leave it to upon your death. It also gives you the opportunity to appoint guardians, particularly if you've got children under the age of 18, and also allows you to appoint the executors. So they are the people who will have the role of dealing with the administration of your estate and ensuring that the terms of your will are followed.
That's great, thank you. You mentioned, having them signed and things like that. There are different ways, isn't there, of actually having a will? Can you do it by yourself, or do you always have to have a solicitor?
So you can prepare a will by yourself, and there are companies online, or you can get will packs from various companies. So you can prepare a will yourself. However, unfortunately, I've seen it go wrong too many times when somebody's made a will themselves. By ensuring that you have a solicitor or a professional advisor to assist you in preparing a will make sure that the will has been validly executed, which means it's been signed and witnessed correctly. But it also means the solicitor can give you all the advice that goes around with it. For example, they can discuss tax planning with you. They can also discuss possible issues that might arise when you pass away, which you might not think about, but it just means the solicitor can give you that necessary advice and ensure that if the will could be or a claim could be made once you've passed away, that the solicitor's giving you that advice, and if there's anything else that you need to consider.
Yeah, and I think that's really important. It's each to their own and how they want to do it, but I think if your situation's more complex, or you want things a certain way, it's always worth getting advice.
Absolutely. Nobody's situation is the same as the next person's. Everybody's very different, and I think the world that we're living in today, there's more complex matters. People have second families. There could be issues with regards to beneficiaries. So it's really important, I think, to get that advice and make sure that the will is prepared correctly, and it's getting the advice and making sure that everything is going to be dealt with correctly once you've passed away. Yeah.
And what about, because they say you should update your will quite regularly. Now, we have a lot of carers who go, yeah, I've got a will. And you're like, well, when was the last time you actually looked at it? So that's quite important, isn't it?
Absolutely. There's no set rules as to when you should update your will, but I always say to my clients they should review it every couple of years. That doesn't necessarily mean needing to come and see me, but perhaps just look through the copy of the will at home, make sure that it's still doing what they want it to do, or the beneficiaries are still the same, guardians, the executors, and it just means that clients get into that habit then of updating the will, particularly if there's any changes. People need to be aware that, if, for example, they were to marry, marriage automatically revokes a will. So they need to be aware of that. They definitely need to update the will then. But also just changes of personal or financial circumstances could be a really important reason to change the will. So although you might have made a will several years ago, just have a look through it. If it's still doing what you want it to do, absolutely fine. But it just gets you into that habit of changes of circumstances, get you to change the contents of the will and just to review it.
Yeah, that's really important. And what about joint wills?
So you don't quite often have a joint will. Quite often a couple will prepare what's called a mirror will. So for example, husband and wife will prepare mirror wills. So in effect, they're doing the same thing as each other. So it will be, for example, husband and wife leaving everything to each other, and for example, then down to their children. So in fact, upon the death of the first of them, there might not be any need to change and update the will for the second spouse. But again, it's important to review things just in case there's any changes. So yes, you don't necessarily get a joint will. We do still, as some people say, I prepared a will with my husband, he signed it. You would have had your own will. So again, it's important just to review things and make sure that it's still doing what you want it to do.
Okay. Do you have any kind of maybe tips or insights for carers who might be doing their will, things that they might need to think about?
So I think for them, again, it's reviewing and thinking about their circumstances. So what we would do is at an appointment, we would have the chat with the client. So first of all, we would go through and discuss assets and financial information. And the reason that is that's one of the tests for capacity for making a will, which I know we'll speak about in a moment.
Gosh, yeah.
But also to make sure that actually if there's any additional advice that they need, do they need to have any financial advice or inheritance tax planning that we need to consider? But we will then go through and we will go through step by step with the client. So for them to consider the executors, if there's any guardians, and then ultimately who it is they wish to leave their estate to. Now, particularly with some of the carers that you may be having that use Solihull Carers Trust, they may have beneficiaries that actually may need trusts to be created within a will in order to try and protect and ring fence assets for those beneficiaries. So again, I think it's really important that if any of the carers listening have got any beneficiaries where they'd like to leave assets to, but potentially this could cause problems or they need to ring fence assets, that again, they come and speak to us and have a chat with us so we can discuss it further with them.
And an example that I've come across is, say, a child, a parent might be supporting a child who has a learning difficulty, who struggles to live independently, and they want to give them some money, some inheritance, but they also know they can't manage that effectively. So would you mind just saying how that might work?
So what we can do is we, again, have a chat with the client and we could discuss about including a type of trust within a will. Quite often referred to as a discretionary trust, but it can be labelled in such a way that it is for the benefit of the disabled beneficiary. And I apologise for using that phrase, but that is sort of how the legislation refers to. Absolutely. But the idea is that provided that beneficiary does fall under the categories of a disabled person as per the terms of the law, then such a trust can be created so that in effect the monies can be looked after and ring-fenced for the benefit of that beneficiary and can be provided to them for the rest of their lifetime. Again, it's quite complex and having to discuss the tax laws involved in relation to that. But again, there are types of wills out there that would allow, carers, clients to provide monies for certain beneficiaries. And again, it's then the importance of who it is they would like to appoint as their executors and trustees, because they would then look after those monies for the benefit of that child.
Yeah, and I was just going to say, for anyone listening who might not be aware of what an executor is, can you explain a little bit more about that?
Absolutely. So the executor is the person who will deal with the administration of the estate. So the role of the executor, in effect, is to collect in the assets of the estate, pay the liabilities of the estate, and then distribute the estate according to the terms of the will. There may be a need to obtain the grant of probate, which in effect is the legal document confirming that the will is valid and confirms that the executors have the authority to deal with the estate. And it means that they will deal with looking after those funds, if they're also named as the trustees, for those beneficiaries, if a trust has been created under the terms of the will.
So every kind of will would have an executor, wouldn't it?
Absolutely.
And they would need to think about who they'd want that to be.
Indeed. Executors can be beneficiaries. So actually, if you have got beneficiaries, adult children who are capable, they can be executors. They can be independent people. And again, it would very much depend upon the situation. For example, if you are looking at creating quite a complex trust within a will, or there's a complex family situation, you might prefer that actually it's independent executors and trustees that are involved. And that could be different family members, friends, it could be professional persons. So quite often the the partners of Sydney Mitchell would be appointed as executors. And again, they could then look after and manage those funds. So you're taking out any emotional side of things, and it's actually, this is a professional, this is what we need to do, we're following these instructions, and you're taking all of the emotion out of that.
Brilliant, because that is a question that we get, and a lot of carers might not have anyone, so knowing that they can get that support is vital.
Absolutely.
So Shelley, you briefly spoke to us about inheritance tax and gifting. Could you speak more on that?
Of course. So everybody has what's called a nil rate band, which is the amount you can give away on your death free of inheritance tax. It's charged at 0%, and that is currently £325,000, which some areas sounds a lot, other areas, if you're in London, doesn't sound like a lot. So particularly with house prices going up, the nil rate band hasn't increased as much as people will have wanted. So just talking, I won't discuss in relation to lifetime, but upon somebody's death, you can give away up to £325,000. Now, there's no inheritance tax due between spouses, so between a married couple, they can leave everything to each other, however much that may be, 325,000 or a few million, no tax to pay. Now, when the surviving spouse passes away, they can, their executors can claim or apply to transfer the first spouse's allowance, which in effect means between a married couple, they can leave up to £650,000. There is an additional allowance that has come into effect called the residence nil rate band. Quite complex, but again, provided certain criteria is met, then potentially, if the full allowances are available between a married couple, they can give away up to £1 million before inheritance tax becomes due.
Gosh.
However, that doesn't include gifts that are made during lifetime. So with regards to gifting during lifetime, everybody has an annual allowance of £3,000 per tax year, and that's one £3,000. It's not £3,000 to lots of different people. If you make a gift of more than £3,000 in one tax year, you then have to survive for a period of 7 years for the value of that gift to fall outside of your estate for inheritance tax purposes. So the nil rate band I spoke about, just the £325,000, if actually you made a gift to someone of, say, £100,000 and then passed away within the 7 years, it reduces that nil rate band that is available.
And you'd have to pay tax?
Not necessarily. Again, it depends upon the total value of the estate. So again, I think that's another reason of perhaps getting some professional advice with regards to preparing a will, because solicitors, professional advisors would go through, discuss the value of the estate, ask if gifts have been made, and work out to consider if there's likely to be an inheritance tax liability, and if so, is there anything that the clients can do to mitigate that now during their lifetime, and things that they just need to consider. The one thing I would say about making gifts, obviously you're entitled to do so. Gifts to charities are completely exempt from inheritance tax, so you don't pay any inheritance tax. Absolutely, and you don't have to survive for the 7 years after making those gifts. But what I would suggest is making a clear record. So the date of the gift, who it was made to, and the amount, because ultimately it's just going to make the job easier for your executors when the time comes to fill in any such forms. But again, if you're not sure, and before you're considering making any gifts, particularly large gifts, get some advice.
Definitely. We have carers that, may have grandchildren and they want to gift them while they're still here. So £3,000 a year.
That's it.
So say if I wanted to give Billy 1,000 and Mary 1,000, and then for that year, and I went up to 3,000, anything over that then would be?
You would then, in effect, have to add on the value of those gifts to the value of your estate upon your death. The other thing to be aware of is considering who you're making those gifts to, and again, the intention as to why it is that you're making those gifts, particularly if it is that you are likely to or may need care in the future as well.
Yeah, which is, I know, a big issue for some of our carers who are thinking about, obviously they save their whole life for their house, and a lot of them obviously want to give it to their children.
Absolutely.
So that's a big question, but it's something that they do have to be mindful of, that I think especially in these times now that, it can be seen as There is a proper name for it, isn't there?
The difficulty is with making gifts, and particularly a lot of people have got concerns with regards to I've worked all my life, I've saved all of this. If I have to go into care, everything's going to be used to pay up care fees. Yeah. And again, I think it's just to be aware of what you can and what you can't do. And again, there's things that you can do within your wills to try and protect sort of some assets. And again, that's looking at creation of trusts, which again, that's not something you're necessarily going to do making a will at home. And again, it's making sure that you get that advice as well.
Definitely. And I think that is a big message as well that I wanted to get across to carers, is that just seek that advice.
Absolutely.
Because everyone's situation is so different and it's so complex. So I would advise that. So we've mentioned gifting and the intention of gifts and around care costs. Can you speak a little bit more about that?
Yeah, absolutely. So this is something that my colleagues who deal with continuing healthcare funding and care funding would probably discuss further. But you need to be aware that if you then start giving away assets, and that could be transferring a property to somebody or giving away lots of sums of money, that if you then required care, the local authority can look back into those gifts. And if they believe that you have deliberately deprived yourself of an asset, they can, in effect, state that that gift was null and void. So you need to be aware of that. Again, we would never advise clients just to transfer their property to family members. There's a lot of cons for that, and we would always suggest that they seek advice in relation to that. We can, within wills, prepare trusts. So in effect, that you can try and ring fence and protect half the value of a property should a surviving spouse, for example, require care in the future, but also, for example, to try and protect assets should the survivor remarry, or again, as I mentioned earlier, second families. So again, of trying to ensure that, for example, if husband and wife are on second marriage, they've both got children from previous relationships, that their respective half of the property is going to their respective children. And again, it's just making sure you're getting that advice and discussing that. It might not be suitable for some families. It might be exactly what it is that they need for others.
Yeah. And like you say, there's so many blended families now. Yes. Everyone's so individual that it is important to get that advice.
Indeed. Everybody's situation is different. And as I say, some types of wills or advice will work for somebody, but not for someone else. And that's why it's important to get that advice.
So, Shelley, another one of the things that are raised with us through carers is the term mental capacity. We have carers that are supporting people with dementia and a variety of different conditions that may affect mental capacity. And I know this has a lot of legal implications for wills and for power of attorney. Could you speak on that?
Absolutely. So ultimately, when somebody's making a will, they need to have what's called testamentary capacity, which means they have the knowledge and understanding of preparing a will. It is an extremely high level, the test is. And again, this is where I would strongly suggest that if a carer or anybody listening who's interested in preparing a will, if there has been any suggestion that a client has the start of memory loss, or even if there's been a diagnosis of dementia, that it's still important to consider if you look to make a will. Just because somebody has got a diagnosis doesn't mean they haven't got capacity.
Yeah.
But of course, capacity is time and issue specific. But again, it's the importance of getting that professional advice. If somebody has got a diagnosis of dementia and makes a homemade will, there's not going to be any reference with that. There's not going to be any test for capacity. Whereas if they go and see a solicitor will use their experience, make sure they've got good, clear attendance notes. They can carry out a formal assessment, and if necessary, get an independent mental capacity assessor out to ensure that actually everybody's in agreement that that person can make a will. And again, with all of that, I won't say it's less likely. Somebody may still well make a claim, but you've got all of the evidence and the information to back up. So again, even if there's been a diagnosis, it doesn't mean somebody hasn't got capacity. They may well have lost capacity, but again, I think it's something just to review, and particularly if it's short, if it's very at the front of the diagnosis, if it's only recent, come and see somebody as soon as possible and get all of your affairs in order.
Yes, because I know that they do say it's time and day specific. Sometimes mental capacity, they can be very clear in
it is
in the morning, but in the afternoons when they start getting confused. So, the tests now, they work around that, don't they?
Of course, whenever we're going to see elderly clients, again, particularly if we know there's a problem or an issue, or we think there may be, again, we will ask that question. Is it better to see mum, dad, auntie, uncle, whoever in the morning or the afternoon? It is very much time and issue specific. Making a will, as I say, it's extremely high level and high test for capacity. But actually, dealing with day-to-day things, somebody might be able to deal with signing a cheque or paying a bill. They might not be able to make a will, but again, capacity is time and issue specific. So again, we'll discuss this with the powers of attorney. But if you're assisting somebody who's losing or has lost capacity, you do need to consider that as well, that it is time and issue specific.
Thank you. And, we will have some people that will say, I haven't got a will. What will happen to my asset? Do I even have assets? And, it will just go to my children. Or what would happen if someone didn't have a will?
So having a will make things easier, ultimately.
Mm-hmm.
You have executors, and that means that upon the death of the person, with a valid will, in effect, the executors can step in straight away and start dealing with things. Without a will, if that person owns a property, for example, there'll be a need to obtain and apply for the grant of letters of administration to the probate registry. There's set rules as to who can make that application, but ultimately the administrator who gets appointed, the administrator in effect will be the same as an executor, but they don't have that authority until they're appointed by the court, and that can take several months to come through. So in effect, not a lot can happen. But I've had conversation with friends where they've said, we haven't got anything, we've got nothing to leave, as I'm sitting in their house. To which they said, but there's a mortgage. And when I delve a little bit deeper, actually, there's a life insurance which covers the mortgage. So they have got something to leave. So it is important to make sure that actually you do prepare a will, because you might not have anything now, but you might have something in the future. Of course, it's then important to review and update the will, which we've spoken about. But also it just means that, whatever you may have when you've passed away will pass to the people that you want it to go to. And again, particularly if you've got children, it's appointing the guardians that you would want to be able to look after those children if anything happens to you, and also the other parent.
Extremely important.
It is.
And I think especially if we have parent carers.
Okay.
And I think it's something that they can think, oh, that won't happen, or things, and we hope it never happens, but it's something you need to think about.
Of course, you always think it's never going to happen to me, and absolutely you never want it to, but you have, and in my line of work, it's always thinking of the worst case scenario.
Yes.
And I think if you've covered yourself, if you've prepared a will, if you've put things in place, it does mean if, God forbid, the worst did happen, you know that the people that you want to act as the executors, who you want to be the guardians, they're the ones that are going to be making those decisions, looking after children and making sure that your money's going to who you want it to go to.
Yeah. And again, so we speak about blended families, things like guardianship is really important, isn't it?
It is. And again, there's lots of rules with regards to parental responsibility and who can be the guardians. And again, if any of the carers have got any specific questions, or again, if there's issues involved, we're more than happy to have that conversation and go through that with them.
That's brilliant. Well, thank you very much, Shelley, for talking to us about wills and power of attorney. There's a lot of important advice there that we hope we can pass on to carers. We do hold wills and power of attorney workshops that will be in our 6-month programme that you would have had recently. If you're unsure of when our next session would be, you can look on our website or give us a call on 0121 788 1143. I will link in the show notes all of the details that we may have spoke about and links to Sydney Mitchell. Thank you, Shelley.
Thank you very much, Michelle. And also, anybody's got any queries, then don't hesitate to contact us directly. Thank you.